Okay, good afternoon, everyone. I would like to welcome the public to the Administrative Services Committee meeting for June 30th, 2025. I will call the roll. Chair Craig Cobb is here, Vice Chair Jim Petrus, and Member President of Council Tony Kuda.
Here.
And also joining us is Council Member Gail Larson.
He's not on yet.
And joining us as soon as he is admitted into the waiting room is Council Member Jim Posh, who is in California on business.
Can you hear us?
I hear you guys.
All right,
Thanks, Addie.
Council Member Posh, thank you for joining us. Hopefully you were able to access a copy of the agenda that's been posted online along with the documents. The first order of business on our agenda is consideration of ordinance number 131-2024, which is an ordinance amending Chapter 105 Public Records of Part 1 Administrative Code of the Codified Ordinances of the City of Cleveland Heights by adding Section 105 Rules for City Emails. By way of background, this is an ordinance that was introduced by Mayor Sarin last either August or September, and it was referred to the Administrative Services Committee. I put consideration of that legislation on hold because I thought the introduction of it when it occurred was political, and I wanted the mayor to complete his investigation of the alleged violations of the Sunshine Law before I would consider that legislation. As recently, I think, as June 18th, the mayor, in fact, mentioned this legislation and called me out for holding it up. So we're going to review that legislation tonight. I have also taken the liberty of drafting some changes to that legislation, which are online. They're really not substantive changes. So if I'll just go through this real briefly. In the subsection A, I changed where we just had Ohio Revised Code. I added in Chapter 149 so we would know where in the Ohio Revised Code that was at. And then in subsection B, I expanded who was to be provided an email account to include not only city council, but each city employee. I then went further to add that the mayor may provide an official city email to anyone providing contract services to the city. And then I put a prohibition that no other person shall be issued or allowed to use or access a city email account to prevent anyone else, such as a family member, from having access to or using our city email account.
Or a non-employee.
Or a non-employee, yes. And then in subsection C, I changed it a little bit to a note, when practical, and then subject to the provisions of Ohio Revised Code Section 149.43, official city email accounts shall be used by the mayor and members of council. This provision also prohibits city employees from using a personal email account when conducting city business. I felt it important to add Ohio Revised Code Section 149.43 because that is specifically the Sunshine Law and public records. And also, when practical, because there could be circumstances where one does not have their city email account loaded to a personal device. The only official city device that we have given has been our laptops. There are occasions where you may want to be, on vacation or out of the country and you don't have access to that. So that is my intent behind when practical. And if anybody has any questions as I'm going through that, please stop me. And then in D, it's essentially the same as previously, except I just put when practical, any response shall be sent from the official city email account, again, accounting for a circumstance where you may not have the city's software on your private device or you don't have your laptop with you.
I had a question.
Yes.
Sorry,
Oh, you're fine,
I
anytime.
don't want to go in front of committee members, but on B,
Yes.
we have had occasion to discuss in the Transportation Mobility Committee and the Climate and Environmental Sustainability Committee, if there was an opportunity to set up an account for the committee so that people could email them using the .gov email. And to date, we have not been able to secure that. Is that something that might be added, or, because then each chair could access, only the chair would be able to access.
I don't, and we'll have to get someone in from the IT department, that each of these boards or commissions be set up one email account where it would go to the chairperson
Yeah.
and then a copy to Addie. I don't see why that can't be done,
Thank you.
but we'll need to hear from IT on that. Yes, Jim, I'm sorry. Just, you're muted. Weigh in anytime. Don't wait to be recognized. And that's for everybody here at the table.
Thank you. So my big, I've got, okay, so conceptually, I do use city email. I only can speak for myself. Obviously, I think all of us only use our city email. And the whole process of someone sends something, whether it's text or whether it's to a personal account, I'll forward it to the city email address. But about 10% of the time, I don't have access to my email just because of my travel schedule. The city does not let us access things from out of the country. We know that there's some new changes on the way to our of our systems that would preclude that. I really question the need of this legislation. And I really wish, if we had like an email system that was modern day, and I know we've approved budget numbers to turn our email system to a modern day email system, I would generally be okay with it. But at this point, it just seems like it's until we get to that stage, I'm having a hard time supporting this. And I know you've changed the language to be, when practical. But I think the city needs to step up and update its email system first. And I know that's in the works. I know it's been in the works for a while.
Yeah.
But I'd like to see that done. And one last thing is, it's been sort of alluded to that this is sort of like, this is what we have to do. To be compliant with the sunshine laws. I would ask how many other cities have this exact legislation on the books? Because in my review, I haven't seen any.
Yeah.
That's all I have to say.
Sure. I did take a look to see if I could find any legislation. I did find that I don't have it right in front of me. Some cities that had adopted council rules that encouraged the use of their official city email accounts, noting that there's some, practical limitations to requiring it. And one thing I found in particular was, I think out of California, which was a study of what cities and counties out there had requirements. And most cities and towns had created official email, but most did not have up-to-date policies, and most did not have any legislation requiring the use of it. And this is under the California Sunshine Law, which looks pretty close to Ohio's.
Thank you.
Sure. Any other comments or questions?
Yeah, a couple of
Yes.
things. One thing, first of all, the Ohio Meetings Act obviously does not require this. I think everybody knows that. I think every council person knows that their private emails, if they're used for city business, could be subject to an open public records request. So we all know that going in, and I'm fine with that. I've always been fine with that. Secondly, when I get emails from people in my private email that are saying, hey, can the city do this? Or there's a pothole or, whatever. I want you to listen to this.
I'm listening.
So-
Sorry.
What I do is I say, well, let me forward this to the Mayor's Action Center or whatever. Now, I understand that could be a public records request. Would that be a violation under this, ordinance?
No, I don't think so. You're simply
Because it
forwarding.
wouldn't be a back and forth. First of all, no council people would be involved.
Right. Well, this doesn't address the round robin. All this is simply doing is we're encouraging that we try and use email accounts, which I think is in theory a good practice.
Right. Is there a penalty section?
No,
for this
no,
thing?
no.
All right, and then I just want to just say on the record that I don't know, approximately 10 months ago, in the meetings that Vice President Russell and I had with the mayor and the independent investigator, we said this is fine. And we agreed to this, but the nothing ever wrapped up. So we never got to a point where we said, okay, so here's how we're going to settle this. We're going to do this legislation and we're going to agree to
Right.
this thing. So, the holdup has not been, I just want to make this clear, not on our end. We agreed to this probably, I don't know, conservatively 8 to 10 months
Yeah.
ago. And we did it in front of our law director, in front of the mayor, in front of the independent investigator, and in front of Councilwoman, Vice President Russell, myself.
Right. Yeah.
There was never an objection. I think we said yes in the first 2 minutes.
And I've never received an answer from the mayor as to why he didn't, if he was unhappy with what had happened, why he didn't proceed to file a lawsuit against the council members or council that he believed had violated this. I think he said that there had been no cooperation. Well, then use the legal means to get the cooperation if you have an issue with that.
I want to just say that is completely untrue. We have cooperated every step of the way. We showed up for every meeting. We agreed to what they asked. They just never came to a conclusion and stopped communicating. We were there cooperating.
Yes.
If we didn't do this legislation, if we just put something in the binder that new members should get, that, and we're talking about having Open Meetings Act training every year anyway, to remind people of this revised code.
Yeah. Well,
Or do we need to, do you feel we need to have this legislation as, besides it should be in a training manual, but to not to codify it because it's a resolution, or it is an ordinance?
yes, it would be an ordinance.
To codify it so that we all have to abide by it.
Well, I do think it's a good ideal that we should strive for. There is no penalty in the legislation, even under what the mayor drafted. There's no penalty for
Right.
not violating it. I think it does make a good policy statement that when practical, we will use our emails. And it sort of goes hand in hand now with the next piece of legislation that pertains to the review of our emails. And when Addie handed me packets, they weren't collated. So I think what I originally handed you in that first pack, if you could hand it back. Yeah, in your pack, did I hand you something,
No.
a full set of legislation? Let me see that real quick.
I have the email.
So there's
legislation here.
The whereas clauses are not bolded. I think that's the one.
So let's see, the next item would be 105.04. Does everybody have a copy of that? Wait, hold on a second. Because what the mayor has proposed, I'm sorry, was 103. So 104 is what I've drafted. Does everyone have a copy of that? Here it is.
Yeah, I don't have 104.
It is. Here you go.
One more question
Yes.
on the other one.
Do you have 104?
Unless this is an earlier version of it.
What is this one? Yeah, this is it, 104.
Okay.
Yes. Go ahead.
I'm sorry, I forgot.
Hey, Craig,
Yes,
is this the same paperwork that was shared with us over the weekend?
it is.
Okay, thanks. I have it.
Sure. And just to clarify, I sent an email out to all the council members with this and with no response to be forthcoming, just it was informational copy so everyone would look at it. Now, I have submitted this to the law department for the law department to review it as to form. And essentially, this addresses under what circumstances our city email accounts of employees and elected officials can be reviewed. And this email prohibits the review of our emails by anyone except and by our emails, I mean city council's email, because it is my belief that the mayor has been accessing city council emails. And I think he said as much in a Facebook posting that he made on June 18th, that I was like shocked to read that. And I'm quoting from his email posted June 18th at 10:02 a.m. Quote, I opened an investigation and requested voluntary participation by the council members. And this is end of quote. This is in reference to the investigation about the sunshine laws. Continuing with his Facebook posting, council members have refused to answer questions or provide additional documentation from private email accounts. Period. Continuing with this quote, but in reviewing and analyzing council members' city-provided email accounts, I found additional examples of discussion, deliberation of committee business by quorums of committees, end of quote. My read of that is that he has been looking at our emails, which is, if it is incurred, is outrageous that an elected official is reading another elected official's email account. I understand that these communications are public records, but that doesn't mean that the governor and his communications are public records, that the governor has access to review state legislators' emails, or that the president of the United States can review members of Congress's emails. This is really outrageous. So all this what this legislation does is prohibit that review without consent, or unless it is done by the law department in responding to a lawful records request.
It would have to be a public records
A
request.
public records request, which is reviewed by the law department or should be reviewed by the law department.
And that's the process that every other resident, including council members, utilize.
Yes, I can't find any provision that gives the mayor the right to have access to our emails. So again, this hasn't been approved as the form by the law department, but I'm going to seek to pass this. I'll discuss it in our committee of the whole. I'm going to seek to pass this in our next committee meeting as emergency legislation.
Well, before we get there,
Yeah,
what I'd like to know is this a violation of any state law or anything in our charter? Because I want to follow up on whether or not our privacy has been violated. Because this, as you said, is outrageous. Number one, it presumes that, one person is, just by virtue of the office they hold, that they're the ethical czar, and others are just not. That's just a blanket. This is the way it works. If you're elected mayor, you get to be the arbiter of that, and I don't see that anywhere in the charter. These are things that have to be worked out between the branches, not that one branch dominates the other. So, I would like to ask the law director for an opinion on whether or not, and if we can't ask the law director, because this will be the umpteenth, what do you call that, conflict of interest, then maybe we ask our,
Yes, I think that's a question that we should
For Steve.
direct to Steve for him to answer, because I don't know the answer to that.
no, I didn't, I just want to say that I want to follow up on this. I want this committee to follow up on it.
Jim, did you have some comments? Posh?
Yeah, I actually do. So in regards to council, do we know if the mayor has signed the legislation yet? And do you know if it's gone through the various channels so we can actually use Steve right now? Do you know if that's happened yet?
It has not, but I believe there's only 3 days left, and then I think it becomes law.
Okay. I do think we need to keep an eye on that, and I can follow up with Bill if that's helpful. I have another thing to say, and just as a matter of creepiness, if the mayor's looking at other people's email, that's just darn creepy.
Yeah.
I mean, I know it's public records, and I have nothing to hide. I don't mind someone doing a public records request, but for someone looking over my shoulder every single time because they're paranoid, that's just plain darn creepy. I wonder if, and I do believe there's some evidence out there that this has been happening. I think anybody, there's public records requests that you can do to see if it's happening, and I would encourage the people that think that the mayor's been reading their emails submit a public records request to see if it's actually happened to them. So that's all I have to say.
Do we know if there's an existing email policy that specifies how they can be accessed?
There is some comment on the city's email policy, but it applies to employees. We are not employees. I think that's in the HR manual, but
It's a really important distinction, and it also is not transparent for the mayor to be reviewing our emails without us knowing about it.
And I do believe that, I could be wrong, that when employees sign on and they receive laptops, they do give consent to have their emails subject to review if warranted. That's also pretty standard practice
Sure.
with a corporation, but you're giving consent to do it. And there's safeguards on under what circumstances your emails can be reviewed as part of an HR investigation, or if there's a legal or lawful purpose to do it. Someone goes on sick leave and you need access to their emails, things like that. But I'm not aware of any company that just allows broad access to their employee emails.
I'm so sorry to go back to the last piece of legislation, but I thought of 2 things, and it may end up overlapping onto this too. Council rules are often codified, like ours are in 111. Are the council rules that you looked up, were they codified? Because you said you looked at some.
Yeah, I didn't look. I didn't do a deep dive down on that.
But you see what I'm getting at, because if we did it as a council rule and it was codified in 111, that's the same. This would just be the same thing, put in a different place in our codified ordinances. It wouldn't have any more or less weight, being in a different section of our codified ordinances. And I'm talking about the previous legislation.
Yeah.
The second thing is, and this gets to the phone business, if I do realize, I asked if I could have my council emails put onto my personal phone. And, I don't know if it was too old or, whatever it was, the IT couldn't do it. So the next question, and this may be just slightly off topic, is we probably ought to have a stipend. If we're gonna implement any of this stuff, we probably want to have a stipend for our budget for a phone, a business phone for council members, because do I want a $50 to $100 bill in addition to it? Come on, we're not exactly. That'd be like 10% of our pay.
that's something that we could build into the budget.
I mean, I know that's not part of the legislation per se,
Yeah.
but it seems to me that that's the only surefire way to have, and I think most people do read their phone. I mean, this is not some, discretionary thing anymore. I mean, you really do need to have your information accessed on a device, a mobile device. So, I mean, it's just something.
Tony,
Yeah.
it's what you're saying is a best practice in the corporate world. And I've also seen it with multiple other city governments that, our family has been a part of. Most organizations with a modern day email system is going to give you IMAP access, so you'd be able to get it on your iPhone. It's very secure, or POP3, or through a VPN that'll connect that way. We have an old email system that we know needs to get upgraded. I'm hopeful that we're going to have this access. I asked for it when I got on council and it was rejected. So
you're saying we don't really need two devices
you don't need two devices.
Okay, all right, because I don't want to carry around two phones. I have no desire to do that, but okay, I'm sorry that.
No, that's okay.
Slight
Yeah.
definition.
All right. The next item on the agenda is this, a new ordinance that I've drafted, which will add section 1.05 to chapter 105. Did you have a copy of
I think
that?
I'm already
Yeah,
have
no,
it.
it's fine.
Yeah,
Do you have?
maybe not because. All right, and this is an ordinance to add section 105.05 to prohibit the use of social media accounts and email systems for political messaging and limiting their use to official informational purposes. And this would prohibit anyone from using the city communication platforms, broadly defined to be the official social media account, email address, website, or electronic communication system operated by or managed by, and I need to put in City of Cleveland Heights, where it says city name, prohibits political messaging and requires that it only be used for informational purposes. And I think that what's been occurring now with our city platforms, and we've all received complaints about it, has been pretty awful, and it needs to stop. It has gone beyond simply informational purposes. And so this would prohibit anyone from using a city communication platform to express criticism, support for, or opposition to any person holding public office, advocate for or against any political party, advocate for or against any ballot measure, unless providing a neutral, legally permitted explanation pursuant to state law, engage in or promote political fundraising, campaigning, or partisan activity. And it would limit it to disseminating factual, neutral information regarding city programs, services, and operations, announcing city-sponsored events or public meetings, providing emergency notification and public safety information, and issue legally required notices.
I think this has to go beyond political messaging. I looked at the definitions, and this is only part of the problem, and I actually think it's a small part, a very important but small part of the problem. Settling scores with the media, anything that's personal in nature, because we need to separate personal messaging from messaging that has to do with city business. And I can tell you that during the budget hearing, there were several instances where I wanted to put out a message from council and was denied while the mayor was putting out information that was saying, here's what council says, here are the facts. And, when you have that discrepancy between, first of all, so I would want to include any personal messaging, any score settling with the media, anything that's, and something that grants equal access to the legislative branch to host events that, we'd like people to attend, or messaging about legislation that we're looking at, or, all kinds of things. I think this needs some definitional work.
Should include council's communications as well as the administration's.
Well, this does. This is no city employee, elected official, other representatives. So it applies to all of us if we're using anything.
Yeah, but how do we get access when a mayor doesn't want you to have access?
Well, that needs to be another piece of legislation that needs to be done separately.
Okay, what I'm saying is, I think in addition to political messaging, there needs to be a prohibition of personal messaging that is non-city business. What I've seen is non-city business over and over and over again.
Well, it's sort of covered by number 1 here is the permitted use. So, I'll have to do some wordsmithing to essentially repeat that as a prohibited use, but may only be used to disseminate factual, neutral information regarding city program services and operations.
Okay, you know what? Thank you for that.
But I could add a 5th one. I'll have to give this some thought.
Craig?
Yes. Any thoughts on that, Jim?
Well, what we're seeing, even in the message that the mayor sent out using the city resources this morning, trying to defend himself. The people that have reached out to me have really called that really being inappropriate, and on so many different levels. It's again mixed with misinformation. This is really unprecedented. I hate, other cities don't need this kind of legislation to prohibit the mayor from acting inappropriately, or doing these things kind of, one referred to his message as an abuse of power. I used the same term during the budget process when, he sent out some flaming email against council that was just not full of accuracy. And it did not, there's two sides to this. And I thought it was very inappropriate that we weren't able to specify what we thought we would need to say. I will take you, if you go back to that loss of confidence resolution that we passed. We as council could ask to put that out there, but I would say that that's probably inappropriate. Just like what he's doing with his responses. I don't know if you can come up with the words. It's just an abuse of power. And maybe we need to call him out on it somehow.
Yeah, so I'm thinking of, along the lines of adding and B here in number 5, express a personal opinion or viewpoint, go, expand upon that. But, if someone wants to go ahead and violate this provision, at least we will then have the ability to go to court in theory and get an injunction. And if they violate that injunction, seek to hold them in contempt of court and have some civil penalties imposed. But I would have never in my wildest dreams ever thought that this legislation that we're discussing here in this committee meeting would have ever been needed or necessary. So I'll do some wordsmithing on the prohibited uses to try and broaden that.
Thanks.
Okay.
I would also draw your attention to an email we received via City E-News shortly ago from from Francis, the new director.
I haven't seen it.
And I think we should pay attention to what's being said in there, that reasons that she believes that the communications from the administration have not always been, she believes in communication that respects intelligence, tells the whole story, and works in service of the public good. So if we're putting things into the city e-news that is informational about initiatives that are happening and things people can go to and events, etc., there shouldn't be any interpretation. It's just factual information. So this kind of is disturbing.
What? I don't understand this email that I've just seen for the first time.
What is it?
This is from
The new communications director.
Oh, yeah. Yeah, it's Francis, right?
yes.
Yeah.
Wow.
So your legislation, Craig, becomes even more important in terms of how we work with that and what we declare it to be appropriate for city e-news.
Right. And this is in my view, this communication from the communications director would be a prohibited use.
Yeah.
And it would apply to her as a city employee.
Yeah.
Because it does,
Oh.
go ahead, have you seen it?
Why is this going to all?
This is the mayor's wife's friend,
Yes.
Frances, and she's the new communications director.
Mhm.
I wish we could go 5 minutes without some of this stuff.
All right. Well, let's move on with the next agenda item. Wow.
Are you, do you want to move this forward? I mean,
Well, at the end, before we're done, I'd like to bring, first I'm gonna make a motion at the end here that we make a recommendation that we move forward with this legislation. And I'd like to discuss that again in the committee of the whole, so I can work on getting things finalized so we can get this passed.
So just so you know, in committee of the whole, we won't be able to go,
No, into this step, I just need, everyone's looked at it. Anyone have any objections or problems with it? If you could give somebody 30 seconds if they do,
yeah. Well, I'll do the 1 minute.
because I think we gotta get something. I
Yes,
mean,
yeah.
this is two communications today that would violate this prohibition. Okay, the next item on here is a new ordinance amending chapter 121.05. Providing rules and regulations relating to the mayor's authority over city property. And I have thoroughly searched first our city charter, and there is no provision that I find in the city charter that gives the mayor care, control, and use of any of the city property. The only provisions where I have found that to be the case are in our ordinances. And therefore, it is my opinion that council has the authority to amend those ordinances to make control of the use of city property subject to oversight by city council.
The third whereas clause, can you give an example?
Whereas concerns have arisen regarding actual potential or perceived misuse of this authority, warning a mechanism for city council oversight. So, for example, the installation of what I understand to be a security camera in the law department in the hallway,
On the inside of.
on the inside of the hallway,
No, on the inside of the law department or?
inside of the law department.
Inside of the law department.
Yes. So that would be something, we could pass a resolution objecting to that occurring and require its removal.
For clarification, so was this done by the administration without the knowledge of the law
Let me
department?
see. I haven't seen the camera.
I have.
I've been told.
No, I've seen the camera.
Yeah.
I've been in there, I've
Okay, so
seen the
it's a new
camera,
camera.
I know where it is. It's, if you walk in the door, once you get inside the law department door, it's facing you on the far wall. That's the one I saw. If there's
Yes.
more than one, I mean, there could be more than one. That's the one I saw, because I didn't go in any further than that. Because I think I was going to see Bill Hannon, he wasn't there. But I was in, so I saw that camera.
So that's one thing that comes to mind. I don't know what else is going to be happening in the next month or two, but I think we need to be preventative because again, I'm concerned about what's going to happen in the next month or two.
So obviously there could be an unintended consequence here. Mayor wants to do X, mayor and council won't get along, council doesn't let mayor do something they may want to do, or they maybe should be doing, I don't know. What's the check and balance on council's authority over the facilities?
Well, it's going to require a supermajority of 5 council members. Again, I would hope that we would only be using something like this under the most extreme measures. The intent of this legislation is not to micromanage or to, there's abuses of authority that are occurring that no one ever envisioned would happen. We need to do something. If people are comfortable that this legislation expire at the end of the year, I'm fine with that. But some of this is preventative.
Mr. President, so we have a meeting scheduled for the 7th, is that correct?
Yes.
Do we envision voting on these pieces of legislation then? Is that our goal?
Well,
Because I agree that many of these feel really time sensitive and important and relevant. Is our goal to pass them on or before the 7th?
on the 7th, I need the law department to approve them as to form, and Bill said he would try and take a look at that to get that done.
Yes, all that is possible. What I don't think is possible is that we run it by Steve, help me with the last name.
Byron.
Byron, unless something happens quicker than I thought with signing off on the legislation. But if that's not an issue, and we're only sending it over to form, what difference does it make whether another lawyer looks at it or not? If it's a code for form, so I'm all for that. Yeah, should have been done yesterday.
Whoever thought we would need it.
How are we doing on time? Okay.
5:21.
We have
Yeah.
a few minutes left. So can I get a motion from the committee that we would like to move this forward to committee of the whole and ultimately the council for consideration and a vote?
Which
Of all of these pieces of legislation. So that would be ordinance number 131-2024, and then the new proposed ordinances. The first one being to amend chapter 105 to add section 105.04 to prohibit the review or access of city email accounts. The new proposed ordinance to add section 105 to prohibit the use of city social media accounts. And the new ordinance amending chapter 121.05. And just to be clear, all this did was it added on a paragraph to the original legislation. And it says, notwithstanding the foregoing, which is the one that gave the mayor control of city employees and care and control of use of all city property. Notwithstanding the foregoing, any use, rule, or regulation established by the mayor relating to the care, control, or use of city property shall be subject to override by a vote of 5 city council members through duly adopted resolution. Upon such vote, the specified use, rule, or regulation shall be deemed null and void to the extent of the council's resolution.
Mr. Chair, I'd like to motion to advance the 4 pieces of legislation described under section 2, proposed legislation of today's agenda to committee of the whole for consideration.
I second that motion.
Okay, all in favor? Okay, thank you. The next matter on our agenda, Jim, did you want to weigh in on any of this before we move on?
No, I mean, I'm very favorable of this. I mean, I don't, maybe what you do when we talk about this in the committee of the whole is we do put a limit on it. Because we're really trying to solve this abuse of power issue right now. And I know members in the law department are frustrated with this new camera. It's clearly retribution in my eyes. But the mayor can do it. He's duly elected. And I think there needs to be a better check and balance there.
Okay, thank you. The next item on here is the commission board vacancies. Unfortunately, I didn't have a chance to sit down with Addie and go over all of the vacancies. We did have maybe we can go into executive session to discuss the one vacancy and filling that.
In Climate and Environmental Sustainability Committee.
And another committee, the recreation. Do you have that person on the climate sustainability? And mine? I thought we already did that.
I don't, if you did, I didn't.
Okay,
Oh, I'm sorry. I didn't know if we got any applications in, so we're gonna go on the applications we already have.
yeah,
Okay.
okay. Okay, so let's move on to other. Anything else that we want to discuss? We only have a few minutes. I know at some point we need to resume discussing chapter 111, but these other things came up.
Yeah. They kind of moved to the back of my mind too, but we do want to finish that up.
Yes,
And
Make good progress.
we have made good progress, and I don't think we have a long way to go. I think we're like more than halfway through it.
right.
But what we need is drafting and, we need to finish the ones at the back of the bus and then start legislating.
All right.
So I'm glad you brought that up.
Is our committee of the whole at 5:30 or is it 6?
It's at 5:30.
Okay, well, why don't we bring this meeting to a conclusion then? That gives us just 5 minutes before break.
Yeah.
All right, thank you, everyone. The meeting is adjourned.